Hello, everyone, and a
Hi.
very warm welcome to you all. Thank you for joining us from across the globe for the second edition of the SIAC-YSIAC Viz Moot webinars, this one titled Strategies in Oral Advocacy. My name is Hannah Wee, SIAC Strategy and Development Manager Legal, and I'm pleased to be your MC today. Firstly, some housekeeping matters. You may send your questions to the panelists using the Q&A function during the panel discussion. As we have limited time, the panelists will try their best to address as many questions as possible. And we will jump straight into the panel discussion. This panel will be moderated by Mr. Samuel Long, Registrar at the SIAC, and our panelists are Ms. Sophia Elena Kozak, Member of the YSIAC Council and Counsel at Sutru Partners, Mr. Sean Pereira, Member of the YSIAC Council and Counsel at Three Crowns LLP, Ms. Lillian Wong, Member of the YSIAC Council and Partner at Shern Delamore & Co., and Dr. Jean Ho, Associate Professor and Director of the NUS Law Academy, Faculty of Law, National University of Singapore. And with pleasure, I now hand the time to our moderator. Samuel, please.
Thank you very much, Hannah. Thank you, everyone, for tuning in. It's a pleasure to be with you, and what I expect and fully anticipate to be an exciting, interesting discussion in anticipation of this year's Moot. And so, just on behalf of SIC, we'd just like to express our thanks, first of all, to our panelists, whom I will introduce in a moment, as well as to everybody, and just to express our excitement at being the chosen set of arbitral institutional rules for this year's Moot. I haven't confirmed it, but I think that we may be one of the first ones to have two sets of SIC rules potentially sort of at play, so to speak, within this year's Moot problem. So it's very exciting. It's a very exciting time for us at SIC. Of course, as you know, this is one of a number of events and webinars that we have put in place in preparation and in anticipation for the Moot. And in hopes of sort of engaging with the student community, the Mooties community, as it were, and in hopes of giving you some helpful and insightful input into your preparations for what is, I think, the oral rounds in particular that is coming up. And so just to situate ourselves a little bit, we are from what I understand, in the presence of some Moot and mooting literati. There are some serious sort of mooting credentials that are in the virtual room, and so I'm sure, like me, we can't wait to hear from their insights and their helpful tips and tricks in terms of preparing for the oral rounds in particular, when dealing with the Moot and the Moot problems. Of course, the first caveat will be that we are unable to deal with substantive questions arising from the Moot problem. That's very clear instructions given by the Moot directors about not allowing the students to sort of find their own answers and find their ways to grapple with the substantive questions. But as much as we can, we hope to give you helpful tips about oral advocacy at the Viz. The other thing that I'd like to encourage is that we do encourage questions, and thank you, Hannah, for pointing out the method and the means by which questions can be asked. And so we will pick them up as we go along, and we certainly encourage you to engage with us through that medium, which is the Q&A function on your Zoom. I think this session will be recorded, so that in case you have to refer to it, or if someone out of the time zone wants to tune in, they have the chance to do so. So now it falls to me also to then quickly and what will be insufficiently to introduce my fellow panelists. And so just let me go through the lists of credentials that we have here. So there's Sophia, and Sophia works as off-counsel at Sutru Partners in Bucharest, Romania, and she focuses on arbitration and litigation and has over, it is not apparent, Sophia, but she has over 18 years of experience in both national and international arbitration, particularly in construction, ICC as well as ICSID arbitration. She often advises clients on contract disputes, construction disputes, post-privatization, oil and gas as well as administrative disputes. And herself being sort of very close to the academic life. She's herself a PhD candidate in the field of commercial arbitration, and is a Moot coach, which for I think the University of Craiova, yeah. And so Sophia knows the Moot very well. So next we have Lillian. Lillian Wong is a partner at Shern Delamore & Company in Kuala Lumpur, Malaysia, and she represents clients in both commercial litigation as well as arbitration, both domestic and international, and across a wide range of sectors, including e-commerce, telecommunications, multimedia, social media, project development, and gaming. So that's quite a unique set of sort of credentials when it comes to the sector spread of Leyland's practice. She also often judges as well as coaches in Moot competitions across not just the Vs, but various ones, including the Voyager, the CTEC Pre-Moot, the UM Moot, Taylor's Moot, both locally and internationally in KL. So next we have Mr. Sean Pereira, who is counsel at the Three Crowns office in Singapore, and he has represented states, state-owned entities, multinational corporations in disputes across a whole range of arbitral institutional rules and across the sectors such as energy, infrastructure, financial services, and construction. Major projects is something that Sean is focused on, and he has been recognized as a force to be reckoned with and a brilliant mind. And he himself is a former magistrate and assistant registrar in the High Court of Singapore, as well as the SICC, the Singapore International Criminal Court, and he had clerked as for the Chief Justice and the Justices of the Supreme Court, and he himself is an alumnus of SMU, as well as alumnus of both the V's team, I believe, as well as a former coach of the very successful V's team from SMU. And last, of course, but not least, Associate Professor Dr. Jean Ho. She supervises and lectures and teaches in various aspects of international investment law, and principally in her areas of research are the laws of state responsibility, the laws of treaties, and investment contracts. She is first academic in the history of faculty to graduate honors from a very prestigious French university, which I will not attempt to mispronounce. And she has also been, it's the first Singaporean to be awarded a placement with I think, a very prestigious council in Paris, again, an honor usually reserved for foreign judges. So in what may be exciting for us is that Jean in particular was the first team from Singapore to participate in the V-Moot in Vienna, and the first Singaporean team to win the competition, the first Asian team to emerge as champions, and the first team ever to win on its debut. So that was recently in 2002. And I think that sort of sums up the credentials and the experience and the rich experience that we will draw from over the next hour or so in terms of preparing for the oral advocacy rounds. And so now I'm just going to try and situate us a little bit. Ladies and gentlemen, we are about a month away from the competition. You know, we are sort of preparing, gearing up for the oral rounds. We are sort of finessing our oral presentations. We're allocating speaking roles, trying to arrange sort of moot practice rounds with various coaches, trying to get ourselves in the rhythm, in the zone for what will be quite a grueling competition when it comes out. And of course, we're also preparing for other pre-moots, right? In addition or in advance of either the VC's round in Hong Kong and or the round in Vienna. And so now let me just give you an outline of what we're going to do this afternoon. And basically, we have a set of 5 themes. And so we are going to have a discussion first with Jean about her experience having won the thing, and then what sort of changes or what the experience was and what that opened up for her post visa, post law school. And then we're going to have a talk about sort of big picture strategy led by Sean in terms of how to approach the oral rounds from a high level. And then we're going to dive into the actual oral presentation for each speaker, and Sophia will lead the first discussion on that, and followed by Lilian in terms of how specifically to answer questions, how to respond to things that or we anticipate will be said by the other side. And then we'll wrap up with any further questions as well as the discussion of sort of life after the V's, so to speak. So I hope that is a good signpost for the session, and I understand the irony of us sort of speaking to you in an oral presentation. So we have to, as physicians, take our own medicine. And so I hope we will keep to time, and I trust that there will be a good sort of an outline for the structure, which we hope to educate you on, and the structure of what will happen over the next hour or so. So let's get the ball rolling with Jean. So Jean, if I can invite you to unmute yourself.
Sure.
So yeah, just taking us back to where we started in terms of situating ourselves. We imagine or try and pull back to a month before the competition, right? You're getting ready for the all rounds. What is the priority for you and your team? How did you prepare, and what do you advise sort of students to prioritize in this time period, a month before the competition?
Um, I'm not sure how people do it these days because, as you mentioned, this was a very long time ago. And I think a month before the competition, a lot of things were already set, you know. The memorials had been exchanged. In our case, which I know is not the case these days, speaking positions were already determined.
Oh,
And so it was really practice rounds for us in the lead up to the VIS. And back then, there weren't any pre-moots, not the publicized ones that you have these days. There were, but we weren't invited to them because we were new and nobody knew us. So we were not invited. We found out when we arrived in Vienna that there were some pre-moots held at some European universities. But then we weren't invited. So we went in thinking like we didn't get enough practice. We didn't get as much practice as other people.
mhm.
But it turns out, well, it didn't cost us anything. I think not
Really?
for the pre-food. So I think we really just focused on, I think number one, having to stay nimble because I think at that point in time, our memorials were not very good, to be honest. We were all quite new to the topic, and because of that, I think it was more about gelling as a team and assigning roles. So that was something which we decided very early on, like who was going to do what, and we stuck with it during the competition. So everything went very smoothly. I think it was a team that worked really well together. So I think I would probably emphasize teamwork, right? In the lead up to the competition. Don't fight with your teammates, and don't fight with your coach. So anyway, yeah, but it was something that I think we made it a point to make sure that there was no conflict in the team. It helped a lot that the team got along personally,
Hmm.
on a personal level. So we didn't have any problems on that front. But everyone was very clear what their role was. So there was no unhappiness over that sort of thing. So
Okay, that's interesting. So, I mean, I suppose one interesting thing is that your speaking roles had already been assigned by this point,
yes.
and is it that sort of the among the four of you, each one had one, and whatever the conflict was, that's the role that you would be.
No, there were five of us and two
Okay.
speakers.
Right. So
So there were only two people speaking for the entire
uh,
duration of the competition.
either for claimant or respondent, that it would be the
Yeah,
same.
it will be the same first speaker, the same second speaker.
I see. I
So
see.
I was the designated first speaker. My senior, Jason Chan, who won the Jessups the year before we went for the VIS, he was the designated second speaker. So we only had two speakers.
Okay. Okay. So that's quite interesting. And so come well, what come what may, that would be the roles. And so you
Yeah,
guys knew exactly what
yeah.
you're preparing
We
for.
knew exactly what we were supposed to do, and it was decided very early on that this
Ah,
was this was the arrangement. So
okay.
I know that's not what is done these days because everyone sort of gets a chance to speak, but that was not the practice. That was not the norm in my time. So
Okay, no,
yeah.
that's interesting. And so, of course, we'll get Sean to weigh in on what the practice is these days, and whether that's sort of advised. But of course, that lends to a certain sort of incisiveness when it comes to practice. I mean, it's a discipline, but we all know what we're supposed to do, and so we carry out our job, we carry out our roles to the best we can. Right? So now and of course at the time, I'm not sure if Hong Kong was already running, but you guys only went straight to
Yeah,
Vienna.
at that time there was no Vis East.
Exactly.
Vis
Yeah.
East came along much later. So back
Mhm.
then there was only Vienna.
Right.
So
Right.
yeah.
So
Yeah.
straight to the, and no national round, of course, because at the time NUS might.
No, yeah, it was just us. So,
Yeah.
people didn't take us very seriously. We went and like, yeah. So I think things only got better, I think, after our second prelim round. Like,
Hmm.
yeah, we weren't being given the side eye that much. And then of course after the break, it got better as we went on
Of
because
course, as
yeah.
you were collecting sort of records or lost collecting wins as you went along the way.
I suppose because they were first surprised we could speak English, and
Oh,
then And then after that, they were surprised that we actually were quite not bad, So it got better. It got better as we
Yeah.
went along.
So,
Yeah.
so great. So exactly. So now you're in Vienna. Now tell us about how that experience was in terms of actually doing sort of going through the general rounds in particular. And yeah.
Well, so you see, when we went, we only had our coach's word to work on.
Hmm.
We didn't have any seniors, so it's not like we could ask them for their experience. Our coach was is my colleague, Associate Professor Gary Bell, and he
Yep.
went to Vienna the year before to observe the Wismut. And then he came back and he told us what happened there
Hmm.
and how he thought we could do very well. So basically, we only had him as a reference point. So when we arrived in Vienna, you could say we were all completely, lost. It's different for Jason coming from Jessups because he has that experience from Washington, but it's not the same as what was going to happen. So Vienna was brand new for him as well.
Sure.
And the rest of us had never attended any sort of mooting competition. So we were four newbies plus one ex-Jessup and a
Yeah.
coach who had been to Vienna the year before. Um, so I think when we went in, we were all just quite wide-eyed. We were given our pairings for the preliminary rounds. We'd never met any of these teams before. We didn't know
Hmm.
what they were going to say. We got their memorials,
Yep.
which we all thought were very good, and then we thought ours was very bad. So I think we really went in without expectations, and just to do your best, but then without expectations. We were quite well trained, I think, by the judges we had in Singapore for our various. We didn't have many practice rounds. I
Hmm.
remember we only had six,
Okay.
but Gary assembled the very best for us,
Yeah.
in those 6 rounds. We had VK Raja on one panel, and then we had some European arbitrators but they're very famous people, right? So we had a lot of people judge us, big eminent names judge us in our practice rounds.
Hmm.
So in Vienna, when we landed there, like I said, we didn't know what to expect. We kind of just went into our practice rounds, just trying to do our best and
Hmm.
answer the arbitrators' questions as best as we could. But one thing I would say we really made it a point to do was to not neglect any aspect of the oral presentation, because it's not just your presentation, it's also Q&A, responding to arbitrator questions,
Yep.
and the rebuttal and surrebuttal. So every aspect we made sure we nailed it to the best of our abilities. I think that's one thing we were very committed to doing. So yeah, and then of course you go through the rounds, and as we went along, we got adapted. I think we adapted to the conditions in Vienna. And I think third and fourth round, we just felt more confident. The first was, I think, against a Russian university. The
Hmm.
second round, I don't remember who we met, but we didn't meet any Asian teams.
Ah,
So yeah, we didn't meet any Asian teams. And then I think the third round we met an American team, and the fourth round we met a German team. They were very good.
right.
So yeah, our fourth round opponents were really good. I remember they were from Potsdam. They were really, really good. So
Okay.
East Germany, yeah.
Right. Yeah.
Yeah.
And
So
and
and so
yeah.
so that was
So
that.
then general rounds, and then of course elimination rounds. You just took it one at a time, I imagine, and
Yeah,
we went
we
along.
like I said, we kind of it was our first time there, and we didn't have seniors to consult. So we didn't really know what to expect. And the I remember every panel of arbitrators being very different.
Hmm.
The tone, the way, the direction of the questions, they were all so different. And one thing we said to ourselves was, our memorial is so bad that we can afford to be very flexible during the oral rounds, because back in those days, you were not necessarily tied to the arguments in your memoranda. These days, I think you cannot depart from certain main arguments that you make. I stand corrected, of course. But
Mm.
back in the day, you could sort of just run a case, and we just refined our case as we went along. So what we said in round four was not
Uh-huh.
the same case that we ran in round one, because
Right.
as we met our opponents, we honed it, right?
Right. Yeah.
And over the course of 4 prelim rounds, we became more confident.
Would
So
you say you picked up some of the arguments that maybe you heard the opposing opposing teams use, and sort of maybe refashioned them in your own presentations as well, sort of in the theme of being nimble.
yeah, we
Uh,
didn't take their argue. I don't recall us taking anything, but we formulated responses
right.
to that. So we were better prepared. I think with every round, we became better prepared for the next round.
Okay.
So
Right.
it just goes to show that even if you go in and nobody expects anything of you, you can get better over the
Mhm.
course of the competition, right? You don't have to go in as a winner or as anything, but you will get better. So I think one thing we had going for us is we were very adaptable because our memorial was so bad. We knew so little, right? That's what Jason kept saying. When you know so little, there's nowhere else to go but up, you see. So we just we just adapted the best we could over, I guess, 4 days,
Yeah,
so
yeah, and that's as good that's as high up as you can expect. So, I mean, while I ask my fellow panelists for any sort of questions that they may have, I'm going to ask you one last one. That's in terms of what okay, so maybe Sophia, you go ahead and then we'll close shortly on this theme.
I was not a Moody, but I was a coach for a few years for my hometown university, and we had a very small team who had to plead both as claimant and respondent, and it was indeed it was a small team, and we didn't have much support. We went there for the experience, and it was a huge experience for our team, and it was also helpful for their career path. And my question is for Jean: do you think it is better, Jean, to plead both as claimant or respondent, or just as claimant or respondent? So to have four members who would always keep their roles, because most of the teams now have members which have allocated roles. For my I had two colleagues, two girls who were pleading, and they were telling me that it was very difficult for them to enter the shoes of claimant, and in half an hour to enter in the shoes of respondent. So that was my question: how do you feel it helped you to plead both sides?
So I'm definitely biased, Sophia, in favor of having your speakers do both, because I mean, we won, right? So I mean, to me, that's a winning formula. But you have, I guess, to find the right people to do it. Um, it's not easy to plead both claim and respondent, but these are the people who would have the best. If you can plead both, you have the best grasp of the case. And what you said, sort of switching from claimant to respondent in half an hour's time. Yeah, that's exactly what we did in Vienna. So for the semifinals, we were pleading respondent. And when we went into the final, because both teams that went into the final were respondents in the semifinals, they tossed to decide who would be claimant and who would be respondent. We won the toss. Okay, so luck plays a very big role in how you perform in a competition. And I said, we have a better case on the merits for claimants. Let's do claimants. So we switched to claimants during the final, and it ended well. So I would say, if you ask me, I mean, for me, a dream team would be one where the people speaking can plead both claim and respondent. But we kept the same speaker for jurisdiction and the one for merit. So in my case, I did claim and respondent for jurisdiction.
Right.
Jason did claim and respondent for merits. So to me, that's a wonderful combination. But I understand these days it's not a very how do you say? It's not politically correct. I feel to have only two people speak. If the team is much larger than two, like everybody should have a chance to
That too.
speak. But we haven't won since, and I wonder if maybe maybe winning's not the point anymore. I sort of get the sense that winning is just not the point anymore, and the point is to go and have a good time. That was not what we were told back then. We wanted to have a good time. Our coach was like, "No, you guys are going to win this thing." So
Yeah. So,
mismatch of
no,
expectations.
no, no, of course, but I don't know that I think that there are sort of that thing, but then there is the usefulness in terms of being agile enough to argue both sides, and that I suppose lends some sort of oral advocacy muscle, right? When you have to swap hats, so to speak, within
Yeah.
a couple of hours. So if you can just take a couple of minutes, Jit. So what has life been after the piece for you and your teammates, and of course Jason Chan? I mean,
This is interesting because we were a team of I was the only third year law student in the team. The rest they're all my seniors, right? So four guys who are all in their final year. They had already landed what do you call that, pupillage positions. These days you call them training contracts.
Mhm.
So I was the only person who was like a free agent.
Right.
So I was inundated with offers before and after before and after Vienna. In fact,
Oh,
most of the offers came before Vienna because, like I said, we had really very high quality practice rounds arranged by our coach. So we basically went around to the major law firms and were judged by the top lawyers.
right.
So, but there were more job offers that came in after the news broke that we won because we had a Channel News Asia crew at the airport. So life was very different. And for a while, I think it was a little bit hard to accept that this was happening. I mean, this is in a good way, in a good way. But because of the competition, because I went into the firm I joined was Sherman and Sterling, so they gave me an offer when I was still in third year. I hadn't finished law school yet, but then I told them I wanted to get my practicing cert in Singapore. So I did my training at Drew and Napier. But by then I had already signed a contract with Sherman. So now it's A&O Sherman. Back then it was just Sherman and
Yeah,
Sterling. Now
that's
it's
right.
A&O Sherman. And that's how I got into investor state arbitration. So I would say this competition has really not say changed things, but decided a lot of things for me. Without this competition, I wouldn't have gone into arbitration and let alone investor state arbitration. And this is the area that I work in right now. So international
Course. Yeah, yeah. No, no, that's absolutely wonderful, and I'm sure that's sort of inspiring to hear for many of our participants. And thank you for sharing. I recall you mentioning that you still remember your visa experience like it was yesterday, and
It's hard to forget that because, like I said, we went in, nobody knew us, nobody cared, we had no expectations. We just wanted to make make it to the breaking rounds and then
yeah.
get eliminated so we could go to this amusement park in Vienna because somebody
Okay.
said one of my teammates went in. Back then there was no Google or whatever. But one of my teammates said there was this very nice amusement park that was quite near the Red House.
Right.
So we were like, okay, so if we make it to the round of 16 or something, right?
Mhm.
And then that's it. We're gonna get knocked out, right? And then we're gonna go and
Yeah,
go to the
3 days.
amusement park. That was all we wanted, really. That we did not go in and like, we're gonna win this thing. No, it didn't occur to us at all.
There's a happy mishap, so to speak. Right. So thank you very much, Jean. So I think that was a good opener in terms of what can happen at the competition, what can happen beyond the competition for our participants, for our audience. And so Sean, we're gonna turn to you now. And what we're looking at now is sort of the big picture strategy. Jean touched a bit about it in terms of speaker allocation, preparations, who to look for your moot judges. How do you go about planning? Again, we are a month away from competition. What is there to do now so that we are at tip-top shape and sort of we're hitting our peak, so to speak, when it comes to orals?
Samuel, I just realized I lost my webcam.
Okay.
So I'm switching over to my laptop.
That's fine. We can see you. Yeah, it's a different angle, but totally fine. Yeah.
All right. So I mean, I just thought maybe I'd start by laying out sort of three sort of scene setting points or framing points before we get into kind of the specifics, the nitty-gritty of strategy and speaker allocations and so on. Because it's a perspective that I've had going to this as a participant and also as a coach after that, which kind of strikes me every time. And I think the first point is the diversity of presentation styles you see at the VIS. You've got a huge number of teams from a wide array of universities. I think it's probably the biggest international moot. You don't have national rounds. So you have an unlimited number of teams from each country, unlike the Jessup. You've got people from different legal systems, different legal traditions. They approach oral argument totally differently. They have very different kind of decorum before a judge or a tribunal. And I think the flexibility of an arbitration moot allows, that diversity of presentation styles to come out in the actual argument. Unlike in a stand-up moot where, it's quite formal, you're standing before a court that sits elevated before you, so you do get a plurality of participants, I think, at the VIS in a way that you don't get at any other international moot, which can be a little daunting, or it was a little daunting for me. And one example that kind of still sort of vivid in my mind is there was a German team, and there was a speaker. He had long hair in a three-piece suit. He was doing a Sir rebuttal, and his Sir rebuttal point was something like 0 plus 0 equals 0, right? So he was responding to a rebuttal. He made no substantive points. It was just a sort of rhetorical flourish. I could never imagine myself doing something like that, but it was so effective. And people were like, wow, that's like such a great way of, throwing a zinger at the other side. I'm not sure I would do it today, or I would be able to pull it off. But it just kind of shows you how different people can pull off different things in the competition. And so I think the first point that I would make is that it's important to sort of find your voice as an advocate. You approach it, you obviously bring a certain style and approach and attitude to your pleadings. And I think the best way to approach it is what would be most authentic for me, and how do I present what I really want to show myself to be, right? So that's something to think about. It's something that I'm even thinking about today, right? You see more senior lawyers do a presentation and you're like, wow, that's pretty cool, but can I pull it off? Is this something I can absorb into into how I do things, or is it something that maybe I can't? So that's one thing to be thinking about, I think, as you're gearing up and you're getting more prepared for the presentation. That's the first point. The second point is related to the first, which is, be wary of the composition of the tribunal. And I think this was a point Jean made earlier as well. One thing that stood out to me at the competition was you've got a big contingent of European lawyers, civilian lawyers, just by virtue of the geographical location of the competition.
Yep.
And if you were from, for example, South Korea or Japan, that might not be as big of a deal because you have your civil codes have the same sort of provenance or a similar sort of provenance. But for me as a common lawyer coming from Singapore, I think I found that a bit of an adjustment, right? I had to shift gears and think about, okay, if there's a legal point, I can't, really rattle off a bunch of case names and talk about cases. I may need to step back, talk about principles, talk about, more general propositions before diving into specific instantiations. So, one needs to be able to have that frame of mind, right? You may come from a civilian system and you're confronted with a common law panel, or you may be a common lawyer, you may be confronted with civilian judges, or very often you have a mix of both on your panel.
Yep.
And you need to, as Jean says, being nimble, being able to tailor your presentation so that you are speaking to both the civilian and common lawyers, hitting points they would expect. I think that's an important thing to be thinking about as you are refining your presentations, your pitch, your arguments, and so on. So that's the second point. Be wary the composition of the tribunal, especially on legal points. You need to be thoughtful about how you're conveying them, how you're presenting them. The third and final point I would make is, a good factual narrative transcends legal systems. So I think many of the most compelling or persuasive teams are those that have a pitch perfect story about the case that they're telling, and it's in a way that they are able to rationalize how each of these facts hang together, right? They are able to draw inferences, implications from the factual material that you have on the record, and also make, educated guesses or inferences as to what you don't have on the record, and develop that into a very compelling, reasonable, persuasive case. I think those are the sorts of teams that do the best. And, as Jean says, it's something that you are doing in a in a accretive, additive way, even as you're going through the competition.
Right.
You are refining the pitch of your case, you're developing the pitch. So that's another thing to think about. There's a tendency as law students to get, lost in the law, legal principles, authorities, case citations, and so on and so forth. But really master your facts, think about your story, and structure your presentation around that. So those were just the sort of 3 general points. I don't know if others in the panel have views or thoughts, or we could talk more about specific strategic calls, decisions, and so on.
Yeah, sure. So I'm going to invite any Lillian, Sophia, Jean, if you have any questions for Sean, or you want to develop any of the points that Sean has helpfully made, and I do appreciate them, right? So it's finding your voice, be wary of the composition of the tribunal, particularly the civil law, common law sort of philosophies or approaches, as well as then this idea of a compelling factual narrative that supersedes or overrides whichever legal philosophy or legal system you come from. So Sophia, please feel free to grill Sean.
I wanted to talk to Sean about exactly what he said earlier about the composition of the tribunals. My experience about some of the tribunal was that some of the members of the tribunals were already coaches to other teams in Vienna, and their questions were sometimes very, very aggressive to the participants. Somehow I thought that this issue was a bit unfair to allow the coaches to be members of the tribunals, because sometimes I thought they would even disadvantage some of the teams. I mean, this was my personal opinion back then, but I don't know, maybe it's helpful to go through fire and pass this test. But indeed, I really noticed that some of the arbitrators were more aggressive. The others that were just invited as arbitrators had a more soft approach, and really wanted, what I really appreciated, they really wanted to teach the participant students, because you have to admit 99% of them won't win, and they have to learn something from this experience. And I thought it was really a thing to be appreciated, that some of mostly the presiding arbitrators were trying to teach the mooties what they have to learn and from this competition. And so
yes.
I wanted to ask about your view about this, Sean.
Yes, I mean, Sophia, that's an interesting point. I mean, it is what it is. I have been. I mean, I recall, and this was in a different mood in the Jessup. My first round I ever did in DC was, I faced such an aggressive question. It was like an interrogation, and I'm usually quite laid back in my style, but I was just responding in kind, and I just got so aggressive. And it was unpleasant. I went out of the round thinking, oh, it was a terrible round. I kind of lost balance a bit. But it turned out to be, I think in Jessup you do get your marks for each round. It turned out that coach scored me the highest of any of the judges that I saw. So, it can be difficult, but I think the only way to approach it is keep calm and carry on, do your best, and it is what it is.
And of course, I think the benefit of the doubt would be that a difficult on the surface judge may actually be the one that sort of is giving you the chance to shine, right? And so if you're able to go toe to toe, so to speak, on the questions which Lillian will talk a bit more about later, that perhaps is an opportunity, a high risk opportunity, to then get sort of those high scores. So Lillian, you wanted to chime in.
Yeah, I just wanted to share perhaps from the aspect of or judges and or arbitrators who are judging the mooting competition. I must at least say that we have heard comments, to at least give you the comfort, Sophia. I think there have been comments where judges have been told, should not be overly harsh on mooters. I mean, not on me, I must say, not on me personally. I have heard comments that the mooters, cry or were seen sobbing around along the corridor. So, I mean, having that in mind, of course, I can't speak for all. I think I must say, when I do judge or sit as a panel of judges in these mooting competitions, I always tell myself, and of course, as much as I would like to tell mooters, but we always prepare the mooters for the worst, right? That I sometimes say judges are not there to embarrass you. Certainly the intention is not to show you that you don't know. But for me, at least I can only speak for myself, it's really to evaluate the mooter's reaction for the purposes of assessment. So even before I throw a question to the mooter, I've thought it through. I wanted to find out, how do you react to this question, because it is relevant for the purposes of mooting.
Right. So Jean, you wanted to say something, and then we can go back to Sean. Yeah.
Yeah, I just want to say to anyone who's mooting that if you come across someone who's unreasonable, an arbitrator who's unreasonable, that's life. Suck it up. No, it's not the sort of thing which you have control over, and there isn't always a happy ending. Where in Sean's case, he got a high score from the one who was most aggressive towards him. Sometimes it doesn't turn out that way, because I recall in our third prelim round, we had a chair of the panel. I don't recall what nationality he was, but he seemed very disinterested in our case. The wing arbitrators were better, two females. I think one was Canadian and the other one maybe was Irish, so, but I don't know, I don't recall where the chair was from. And when we finished, when I think I finished the rebuttal, whatever it was, when we finished, he just looked at us and pointed and said, "You lose." And then we were so taken aback, right? The other team was taken aback as well. And then one of the wing arbitrators said to him, like, you're not supposed to like announce it, at the prelim rounds or anything like that. You're just supposed to give them feedback or whatever it is, and they're not supposed to be told like win-loss.
Yeah.
And so we just thought, okay, our coach got very angry with that arbitrator because it's like, what are you doing to my team? And then we got the scores back after the competition, right? In the way that I suppose they do for Jessups. They send you your prelim round scores. So we got our scores after the competition, and they also told us where we stood vis-a-vis all the other teams.
Yep.
So out of 106 teams that year at VIS, we broke second. Okay, which means we were really good for nobodies, right? We were brand new team. We broke second. The team that broke first was the team that met us in the final. And for that particular prelim round, we got scored so low by that male arbitrator who said to us, like, you guys lose. The minute we finished speaking, he said, you lose. So my point is, you're going to run into people like that, but it doesn't have to determine the outcome of your performance at the competition. So we met someone who was like this. That was very unfortunate, but I guess it didn't really stop us, So just get over it. It's not one of those things where you can say like, well, I hope I don't. If you run into someone like that, all you can do is your best.
Right.
They can either give you a really high score, or in our case, gave us the lowest score imaginable. Like it was just barely passing, okay, for both of us, Jason and myself.
Right.
It happens. It happens, and that's life, So just deal with it, yeah.
Yeah, no, thanks. So Sophia, and then we'll go back to Sean. Yeah, Sophia, go ahead.
I will just add this, that a few years ago, in Vienna, there were over 600 teams. And you can imagine there is a real need for arbitrators. And of course, under the circumstances, you will have a different type of arbitrators. So exactly what Jean was saying, some of them maybe don't even properly know the rules. Of course, for the elimination, for the final rounds, you will have the most prepared and most experienced arbitrators. But you have to be aware that you may end up also with less instructed arbitrators. This is life, and you have to get over it and just continue and shine the best you can. This is my advice. This would be my advice.
Thanks for this. So Sean, we'll wrap up this team with you, and I suppose it's a good segue to note that perhaps you're perfect to speak on this difference. In Jessup, for example, qualification into the knockout rounds or the elimination rounds is on a win-loss calculus. I believe, or well, that was the case when I did it. But I think for the VIS, clearly it's not, right? So it's a raw scores game, and so that may inform us in terms of our strategy, and so I'd like you to respond to that, as well as the second point that you made, this being wary of the composition of tribunal. But here in this case, in terms of sort of the potential perceived aggression on the tribunal's part, or the varying sort of inflation in terms of how well a tribunal will score. So how do you best prepare for the degree of variance across the spectrum of judges that you will see over your general rounds?
Yeah, I mean, so all of the points raised have been very good. I mean, to be fair, I have come across excellent arbitrators as well, judges in the Vis Moot. So you do get good judges, and I think generally people are quite fair and good. But you also do, as Sophia and Jean mentioned, get the odd difficult arbitrator, which may not, necessarily reflect in scores. It may not hurt you. So, I think the best approach is just to kind of stick to your plan, carry on. Don't, as Jean says, I think there's a huge element of luck in any of these competitions. I mean, you've got 600 plus teams. You are narrowing it down to the knockout rounds. You've got so many different parameters. You're assessed on your memorials. You're, Samuel, as you know, on this, you're looking at raw scores, points. So there are just so many variables. I mean, as to that distinction about how the scoring system for qualification would affect the way we play our cards in the qualifying rounds. I mean, maybe I'm just not strategic enough, but I don't really think about that because I think, there are too many unknown unknowns. The idea is, let's go in, let's put our best foot forward. Some control you have, as Jean was saying, maybe on the side that you pick. And even then, that's a pretty simple question. You think, we've got a better case on this, or we feel more comfortable on this side, let's go with this side. That's kind of how you deal with it. But I wouldn't sort of overthink, how we run the team to get the best scores. And, it's really a matter of putting forward the best speakers, putting forward the best case in each round.
No, I appreciate it. Yeah, and it almost sounds like, I suppose, given that it will be a broad spectrum of teams that you come up against, but in particular a broad spectrum of arbitrators, I suppose your job is just to be as sort of presentable or as likable, for want of a better word, to as wide a spectrum of arbitrators that you can meet. And of course, again, your point about being sensitive as to who the composition of your arbitrators or your tribunal is for each round, right? And trying to tailor your arguments to the best you can. Once you identify or you try and sort of understand them without being, there's a danger of stereotyping people, of course, but trying to understand them from where their approach will be coming from. I suppose that's one way to look at it. Would you say?
Yeah, that's exactly right. And there was a point on speaker roles that I wanted to pick up on from what Jean was saying earlier. I mean, we've worked with different configurations of speakers where you have, as in Jean's case, you have one pair of speakers who double up both sides, and usually they take jurisdiction and merits.
Yep.
We've had situations where you have two speakers on jurisdiction and two speakers on merits, one on each side, or sometimes interchangeable, and you kind of figure out who's on form and you play them. I don't think that there has been one particular formulation that has worked best, or at least from my experience. I think a lot of it depends on how the team is set up, how they work together, the strengths and constitution of each of the individual speakers. It can be quite taxing and quite challenging for two speakers to bear the entire speaking load throughout the competition. So I do think that that's something, there's no real golden rule, as it were, and you do need to make decisions based on the composition of the team and team members. But one thing that stands out, and it's a point Jean made as well, is I think when you have speakers that speak on both sides, or at least practice on both sides, the mastery of the case, far exceeds someone who's just stuck in one position on one side all the time. Because when you are having to reverse gears and take the other side, you kind of understand the weaknesses and strengths of the other side much better than you would if you just stay on one side throughout.
No, that's a good point. Actually, if anything, that might be a good practice tool, right? To make speakers argue the other side, just so that you can see the strength of the argument, well, the counter argument, so to speak. No, thanks for that. And so we're gonna segue on to our next theme, and I'm gonna call upon Sophia. So in terms of preparing the actual presentation, to the extent that one can prepare in terms of outline and structuring, how do we do it, and what are your sort of suggestions and guidance in terms of this aspect of the preparation?
Thank you, Samuel. I will tell you about my approach, and from our experience, of course, Moot is developing every year, and maybe some of the receipts turn out to be more successful. But I think some important rules, no matter how times change, there are some important rules which always offer you the receipt as a success. And of course, everybody knows they have to prepare the binder with the evidence and with the case with the evidence. But for a successful oral presentation, in addition to the argument binder, it is helpful for each member to prepare an outline that can be used when presenting the oral arguments. You have to understand that you will be asked questions from the arbitrators, the main reason being for them to test you, to see how the way you react, and under the emotions that you have, you may be nervous, of course. It's the beginning of your career, and you may get disrupted, and that's why you have to present an outline. What is this with this outline? This outline should be like a 2 pages document with bullet points, where you have the ideas written, what you start from, and with what you end up. So it doesn't have to, you have to avoid to have a detailed script to read it from, because if you have a script in front of you, all you will do, you will go flip through the pages, and it will show the arbitrators that you are disorganized. So it's better to have a 2 pages outline. This outline should stand in front of you, and you go through the ideas, just have a quick glance at the outline, because when you finish one argument, you have to know, no matter how disruptive you are, you have to know which is the idea you will continue next. So even if this outline will be in the beginning a 4 pages document, the purpose would be that in the end you have no more than 2 pages to be presented to sit in front of you, and you just have to look at them from time to time, if you need to know how to continue. This would be my advice, and this will communicate it. If you can freely speak, this will communicate to the arbitrators that you have a clear sense of organization, and if you know your ideas, you know the clear ideas and what you have to talk about. The arbitrators will also understand your case. If you can explain something in simple words, then it is clear you for yourself have clarified all your questions. And then if you have prepared this outline, it is important for you to know that you have to have an opening statement. In the opening statement, you will explain to the tribunal who you are and what you are there for. Of course, after you start your presentation by greeting the tribunal good morning, good afternoon, and you introduce yourself and your co-counsel, because the first speaker has to always introduce the co-counsel. This and the client they are representing with a simple formula. Good morning, members of the tribunal. My name is Sofia Kozak, and alongside with my co-counsel Jane Ho, I represent claimant Orchis Worldwide, and then you will have to start with the strong formula and frame the problem. This is what is important for you to note at the beginning of the presentation. So you will do that in 1 or 2 sentences, and these sentences have to convince the arbitrators that you are on the right side of that your side of the argument is correct. So this sentence should be something along the following lines: we are here before you today because claimant is attempting to rewrite the law in its favor. We respectfully ask the tribunal to allow claimant to avoid responsibility not to allow claimant to avoid responsibility for its illegal actions. Something like this. It will have to be there have to be two strong sentences, and at the same time you have to achieve the following purposes: to lay the blame on the opposing party and make a strong use of the facts. This should be the introduction part of your presentation. Secondly, while going through the arguments that you will present, you have to have a clear roadmap, and this roadmap should be presented to the tribunal. Usually, or what we were doing when I was a coach, we used to make for each part like to select 3 or 4 strong arguments and try to present them. Of course, you will have an ample memorial, but you will not be able to present to the tribunal all the detailed arguments and the exhibits you have in your memorial, the references. That's why you will have to stick to certain arguments, and of course you have to start with the first and the strongest argument. And the second argument should not be the lowest argument, because after you present the first argument, sometimes it's natural that you lose a bit the attention of the tribunal, and the last argument should also be a very strong argument in your presentation. And you will have to make this roadmap to the tribunal. You have to speak clearly and slowly. Arbitrators will have to know which are these arguments you will go through, and you will have to guide them. Through.
So if I can chime in at just a question about roadmap, right? And so say your speaker, your first claimant, do you also tell the arbitrators what your co-counsel will say? Do you outline his or her points in terms of providing the entire claimant's case? Or do you just sort of you leave that for your co-counsel and don't try and put words in his or her mouth and stick to it? Well, what is your advice? How much sort of writing checks for my colleague to
my advice would be to present your argument, why the tribunal should rule in a certain direction, but also at the end you should touch a bit on the strongest arguments of the respondent on the other party, and to prove that to weaken their arguments with a counter argument. But the focus should remain on your position.
Sure, right. So focus substantively on what you want to deliver, and then sort of alongside deal with sort of the counterpoint.
If there is a very strong argument on the other side, you have to touch it and rebut it.
Right. So okay, I'm going to just again invite my fellow panelists to come in whenever, as well as reminder for questions from participants to be put into the Q&A. But so I'm going to ask you now, what happens now? I've gone through half of my 2-page sort of outline. and now the tribunal's questions have come in, right? Usually I warm them up, and now midway through the questions are coming, and I'm left with 2-3 minutes. I have one more page to go in my outline, and then timekeeping, of course, is the other consideration, right? Do I dump, so to speak, arguments, or do I just rush and finish it? What would be your advice to the folks that you coach, or to those who are listening?
If you have announced this roadmap and you have announced all three arguments or four arguments that you have on your list, I think you should go through them, all of your arguments that have been announced, even if one argument will not be so developed, but you have to touch it. And if you feel the need that of more time, you should ask for the tribunal to grant you one more minute to go through the last argument. So I don't think you should go. You should give up and not present your arguments once you have announced it. Of course, sometimes you tend to get into the discussions with the arbitrators, but the trick is, in my view, to try to make a transition and tell to the arbitrators when they ask a question, a phrase like "Thank you for your question, and this leads me to the second point on my roadmap, or the second point I wanted to make today, namely the issue about nullity," or something like that. So you have to try with the questions, by using the question of arbitrators, to get back to your roadmap and not get lost in long answers, so that you lose track of what you want to say.
So use the questions as segues into your following points.
Exactly.
So you stay on track, so to speak, and you're not losing time on a tangent too far. As well as, if you've announced the roadmap, you even if it's just a one-liner, I suppose, touch on it so that you're not docked points, I suppose, for an incomplete submission. And would you say always never presume that you have extra time? You always have to ask for time. Is that correct? I hear different things about it, but some arbitrators tend to be quite strict when it comes to timekeeping. Is that right?
I think timekeeping is very important, and you have to ask for the tribunals, and this will give you points if you know how to manage time, because at the end of the day, you will, as a lawyer, you will end up in real life with a real case. And if you have three strong arguments that have to be presented to the tribunal, the client will be in your room, in the room with you at the hearing, and the client will, and for the sake of the case, you will have to make yourself heard. It's a one-time opportunity.
Right.
You need to make the strongest points of your case heard by the tribunal. At the end of the day, we have to look at the Moot also as a real case life, and of course, arbitrators are very prepared. They read the case before the hearing. They know the case, but it's always different when they hear you speaking about them, because about the arguments. It is very important to have credibility, and this credibility is won by your pleading during the oral hearing.
Okay, no, that's helpful. So I just pause in case any other panelist has any contribution on this topic. Otherwise, we will segue very nicely to Lillian to deal with sort of now the responsive part of the oral presentation, right? It's a little bit difficult because you don't know what's going to be said by the other side. You don't know what questions the arbitrators are going to ask. So Lillian, give us your top tips in terms of how you prepare for that sort of unscripted section of one's presentation at the oral rounds, please.
Will do, Samuel. So I think I want to start by saying, why is this, preparing for questions or anticipating questions from the tribunal, why is it so important? I think what I did is I just quickly checked the rules this year again. And I think one of the scoring criteria has remained, it has always been there, that does counsel answer questions directly and use the opportunity to turn the question to his or her client's advantage. So I think there are two relevant, or at least material points here. First is answer questions directly, and second, I think the second part, so, or most of the time, sometimes I find it missing. Always, when I do the general rounds, it's how do you use it to your advantage? So that's very important. So perhaps I can just share that I think every mooter anticipate there will be questions from tribunal. So then the question is, how do you then anticipate the questions? I mean, certainly you can't be guaranteed you'll be asked, but I think it's always useful to prepare and anticipate both questions and answer. So now, say how do we answer questions directly? Of course, it's not as straightforward as it seems, considering the pressure that each oralist is facing when they are being placed in the spotlight. Perhaps just a few tips that I find it useful. I think it's very important. I think earlier on we started by considering arguments from both parties, right? So test your case and anticipate the questions. I think in WIS, we are required to prepare both sides. So I think Sophia also say, I think we have to acknowledge that sometimes we find it's difficult to switch, but it's also through the switching, you lay out your strongest points. And more importantly, to be honest, I must say, I sometimes place equal emphasis on weak points. On your pain points, you have to prepare the answer. You can't fudge it because anticipate that you will be asked questions to address your weak points. I shouldn't say more likely than not, but at least sometime when I'm thinking of questions to ask, I'm not going to ask you to strengthen again your points. I will want to know what do you think about those points and have you prepared for those points that are pain points for that party. So I think it will be useful to have a kind of like a list of questions and points. You might not have the exact answers, but bullet points to respond to weakest points, if at all, if that comes up. So acknowledging weak points and preparing response to them is one tips I would give. Yeah, and okay, what I also do sometimes find it useful is anticipate the categories of questions. What are the sort of questions that may come about? Well, not fun size that fits all. I don't think I'll be able to share. Sometimes what I see, I think maybe 3 categories. One category is there will be questions which require an oralist to take a position, yes, no, or and why, right? So for example, you might be asked, do you concede on this point that there's no written contract, is oral contract, for example, or is your client waiving this claim? And or isn't it that your claim is unreasonable, for example, right? So this kind of question is kind of like, for me, I always find it useful when I would expect an answer, yes, no, then you explain why, because it's kind of like a put question in that sense. So you say, yes, I agree, or no, I don't, because of what? Or sometimes, I'm sure some mooters will find that, hey, that question is not material, not relevant, it shouldn't even have taken into consideration because of whatsoever reason. Then take the opportunity to highlight to the members of the tribunals, yes, my answer is but the answer to this question will not affect the outcome, or is immaterial to the issues that we are running. So that's sometimes I find it useful. Second category, I think is perhaps, most questions will come from, they'll ask you about facts and law, right? Facts, I think that's the easiest to prepare. Every mooters will be prepared and are expected to know your records inside out. So those questions, they will come and say, have you considered ABC? Or can you address the tribunal on the EFG? So those points, again, don't just focus on your strongest point. You should also focus on exhibits and or stuff that you think might not be beneficial to your case. Legal, I think, say if they ask you questions on cases, I've seen tribunals that ask you some random cases, they might even just say, oh no, what is your take about this case? To be honest, sometimes I also find it difficult. So, to the best of your ability, try and answer if you really, have not heard about this and don't know. I think perhaps then you can give an answer to say that, based on your submission, this is the legal principle, but you won't be able to tell what you can't, right? I mean, the last thing we always say is don't bluff your way to say, yes, I know about this case, and this case is about so and so, but it's not. Take it that the moment the arbitrator asks you, they will know already what is that case about. And, for some intent purposes, it might be their cases as well. The last category, I think it's useful to certainly consider the question in which the counterparty, what are the counterparty arguments? So when you do for claimant, you will do also all your respondents' points. So for me, also kind of take it that questions are likely to come on all those counterparty arguments. Again, I must give the comfort that tribunals, they are not siding with one party or either party. So the moment they ask you, don't feel that, oh, they're agreeing with the other side and they think I don't have a good case. Is not at all. They're just checking whether you understand both sides' argument, and they want to test how do you, scrutiny, the scrutiny or scrutinize your responses. But I think sometimes perhaps what I will say, or I can just give a very general tips, is that you can say yes, that arguments appears persuasive, or that yes, this is what they are taking, but it's not the case because of blah 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 blah. So I think I'll pause here because Sophia has raised her hand.
Yeah, that's right. Thank you, Lilian. No,
Yes,
Sophia.
yes.
I was talking about, I wanted to add something about questions, because sometimes the arbitrators want to test your knowledge about the notions that you work with in arbitration. What is commercial arbitration? What is investment arbitration? This happened to us in one of the rounds. And I noticed that the arbitrators want to make sure that when you make reference to a case, if it's a reference to a commercial case, if it's a reference to an investment case, you really have to know that case, the cases you are citing. You have to know what happened there. I know we all are busy, and the preparations are sometimes you don't have all the time in the world, and you will focus on some things and leave others maybe more neglected. But you have to know the basic concept of arbitrations. What is the difference between investment, commercial? Because I remember one of the arbitrators tried to see if the Moot knew what is investment arbitration, what is the relevance of citing in a commercial arbitration a case law from investment arbitration. And you have to speak with your coach and understand these important concepts. They are not easy. You are still students, and of course you have not the experience of arbitrators, but you have to read about them, to find time to inform yourself about these concepts.
Yeah.
Thank you for that. Yeah. Please
So
go ahead, Liz. Yeah.
sorry, just quickly, Samuel, she's absolutely right. And I must also say that, I mean, again, I'm just speaking from my experience, not representing anyone. Be it elimination round or general rounds, or even towards the finals, the tribunal's standard would have increased. So normally, sometimes when we're doing general rounds, we'll be thinking, these are just baby mooters. You don't want to really, go too hard into the questions. And also you see how they react, right? If they're already not handling questions well, we sometimes don't want to be overly harsh. But certainly you must expect, I think all mooters, you must expect that as you progress, it's just going to be more challenging. Yeah.
No, thanks. So I take the point from Sophia. I suppose that's putting yourself in the position of the arbitrator, right? If a case is cited to you, I suppose the question immediately that comes to mind for the arbitrator is, if he or she is not familiar, or even if he or she is familiar, is that what is the weight that I'm going to give to the proposition that is supported by this case? And if it's an investment case that that's quite particular to its set of circumstances, then there has to be the necessary sort of discount or acknowledgement that it can be persuasive, but I mean certainly unlikely to be binding. I mean in the world of commercial arbitration, of course, unless it's the governing law. But sort of being able to not just answer the question, but also then take a moment to flip and say, now, if I were you and I'm looking at this answer from your perspective, tribunal, let me tell you how I would categorize or how much weight I would put on my answer. And that would help you in terms of sort of situating it within sort of the body of authorities that I suppose you are grappling with in the hypothetical situation where you are supposed to draft the final arbitral award at the end of the day. So I mean, I love that point, because ultimately it's sort of empathizing or putting yourself in the shoes of the tribunal at evaluating your own answer as giving it another layer of depth in terms of the discussion that you are bringing about within that short time frame that you have. So no, that's great. And anybody else feel free to pipe in. But I also wanted to ask both Sophia and Lillian in terms of rebuttals. So that's something that, of course, every team reserves the time for, and then every team sort of tries to maximize impact, whatever that means. So I suppose the question for you is, what is a good rebuttal? And I recall, of course, Sean's recollection of that German ponytail male speaker who said 0 + 0 = 0, and sounded like a genius. So with all those sort of input in terms of the usefulness of rebuttal. So Sophia, so maybe I'll start with Sophia. How do you advise the teams go ahead in preparing for this sort of one-time punch, as some people call it?
Indeed, the best arguments are the one who can provide an image or in front of the panel to give a practical case, to make a comparison, and then a logical deduction from that comparison. I think you should, if you know the case very well and the other party's arguments, you should be prepared for a good rebuttal. It's like a conclusion for your entire pleading, and it has to be something strong, short, and right to the point.
No, thank you. Lillian, do you have any, and of course, we'll go to Sean. Yeah.
Sure, just perhaps a few tips. I think, just kind of like building up from Sophia's point, you really want to keep it focused. But what it means is respond to what matters, not everything said, because actually time is of the essence in mooting competition. Sometimes what I find it to be very useful in rebuttal that comes across as a strong point is if there is something that is clearly wrong or overstated, you would certainly want to take the opportunity to refute that misstatements or overstatements and pivot back to what you find it to be correct or useful.
Right, yeah. Stick to what matters. I think that's a useful sort of North Star when it comes to preparing that sort of 1 minute presentation. Sean, I see you've unmuted yourself, please.
Yeah, I just wanted to make a point, maybe a more general point rather than specific to rebuttals. But I mean, I used to think when I was a mooter of my presentation in like a set piece format, right? I have the outline of my submissions in a linear form, and then I have some Q&As for which I prepare questions, and then I've got rebuttals, rebuttals, points that I may want to make. But then I feel like as I got along, and this is how I encourage my students to think about their case, as not like a set piece, but as a loose confederation of ideas, themes, authorities, facts that kind of hang together, right? And they are interconnected in various ways. So that allows you, if you're pressed on one point, you can see how this point may be related to a concern that you are weak on, but you can bridge to another point, which is a strong one, which kind of scratches that itch, but allows you to convey a key part of your case in a powerful way. So, obviously you have a script and it's linear, and that's how we sort of think and present. But it's a useful exercise to take a step back and try and map out how all of these things relate together, and how you would assign weights and significance to different parts of this case, and then that just helps a lot with selecting your rebuttals, answering questions, moving on. Samuel, your question about how if you have 2 minutes left, what do you do? Do you go back to your script, or if you're thinking about your case as a map of things of varying importance, immediately I need to hit this point, I need to hit that point. And I'm not thinking in that linear way. So I found a useful tool when you're preparing for, presentation, questions, rebuttals in the Moot.
No, that's helpful. So having a bit of that mind map, this confederation of ideas, or I think that's a good way in terms of seeing how everything interlinks or hangs together, so to speak. And that, I suppose, will give you an idea as to what to prioritize when it comes to actually sort of presenting on the day. Okay, so we have our final 10 minutes or so, and I think I want to shift gears a little bit, and I'm seeing this on the chat as well, in terms of life after the bits, right? So we've done it, we've gone through it, and I'm going to turn to Jean shortly after this in terms of how do I take best advantage of the V's experience, both at the competition as well as perhaps preparation, because I suppose that's where you meet your local bar, your local seniors, right, in your practice modes, in your interactions with the law firms as you prepare. And how do I take best advantage of it such that sort of allows me to, if I'm interested, develop a career in arbitration post law school, post graduation, or even sort of the general sort of practice or academic life. So Gino, over to you in terms of how to think about that.
You see, these days you have generations of vice seniors, right? Who can serve as judges. So I think a lot of practice rounds, your internal practice rounds, I guess, will be judged by your seniors. I'm not sure how much mileage you get out of that. I mean, okay, your seniors, depending, some of your seniors could already be in very senior positions in law firms. That's great, right? Those who have just graduated, like I said, I'm not so sure. But again, I'm speaking, how do you say, in theory, because in my time we had no seniors. The only people who judged us were very senior lawyers already, and the way to make full use of that, take full advantage of that, is really to do your very best, even though it's a practice round. You can't go in and say, well, just because it's a practice round, I can forget stuff and I can be not as well prepared, I can be late. Because like I said, I got the vast majority of my job offers before I left for Vienna. So this is before we went there and anything happened. So this is just right after practice round, I get a call, I get an email saying that, do you want to come in? We would like to talk to you, stuff like that. Okay. So if it depends on how you present yourself. I think when you go to a law firm and you moot to the partners there, you moot to the recruitment partners there, that's extremely important because, you could have a lot of options if you do it well. And I guess, for pre-moots and stuff, if you do have this opportunity to go for pre-moots, same thing, because you never really know who's watching. So I would imagine that a moot is a great opportunity for you to get to know a lot of people and let a lot of people know who you are. And the only way they're going to remember you is if you're memorable. And so you've really got to put your best foot forward. Yeah, so I'm not sure at the moot because we weren't allowed to go anywhere when we were in Vienna. So unfortunately, we did not really make any friends. It was very unfortunate, right? But we were not allowed to attend the parties. This is the old days when your coach basically, could control everything, right? So I'm not sure what it is like now. I'm sure it's not like this, But yeah, we actually, after mooting every day, we just went straight back to the hotel. So we knew each other very well. I mean, my team and I, and then we didn't know anybody else. So that was, yeah. But I know I ran into we were judged by someone from the ICC Secretariat in our second round. It was a very young Matthew Seacombe, who's now, of course, partner at White and Case. And he remembers me from round two, and I remember him from round two. So yeah, you do get to meet people, and 20 years later you connect, and it's really, I think it's a wonderful experience. It's going to be a wonderful experience for a lot of people. So that's where I met Matt Seacombe actually at Viz. He was my judge in round two, but he was very young back then, and like I said, he was at the ICC Secretariat. So yeah.
Right. Yeah. Wow. No, and I'm sure that full poetic circle has come around a couple of times.
We were in a conference together recently organized by White and Case. So he was, I think on a separate, but he was one of the organizers. And then so I was sort of like, my name was on the list. And then, it's really nice to be able to reconnect in a professional capacity after so many years. So yeah.
Yeah. So, and of course, the VS network being what it is and sort of and ever expanding and ever growing. I mean, I'm sure there are more of these. And so I'm going to call on Sophia and then Lillian and Sean in terms of your personal experience, as well as perhaps folks what have they drawn from the VIS? What sort of ability to leverage. So leverage is a perhaps a too strong word, but what are the opportunities that arise from the V's that can come up in your experience? So Sophia, please, yeah.
Yeah. I think for my students, what I've heard from them and what I know from them is that they received job offers. For them, I allowed them to go to some of the parties, so they
very
had
kind.
fun. They were young students. They hadn't seen Vienna back then, so they were amazed by the people, the high level people they could meet, the opportunities. Some of them went for a career as judges, but some of them are lawyers, dispute lawyers. So I think it helped them a lot. It was they named it as the greatest experience of their life, and most importantly, they had something really relevant to put in their CV. Every high level lawyers know what Vismut means, what abilities you have to be even selected to attend this contest. So it is something very, very useful for a young lawyer to have in the CV. And yes, it is wonderful if you can win the contest, but if you can't, just enjoy the experience and learn from the question of the arbitrators and learn from the experience and just enjoy it. This is for me the most important thing, to enjoy the experience and take the best out of it.
Wonderful. Thank you, Sophia. Lillian, what is your experience and your advice in terms of, I suppose, your closing remarks? Yeah.
Yeah, I must say, I actually really do echo what Jane and Sophia said. Sophia started by saying 99% of people will lose. I'll be thinking, oh my God, this is like so real, right? It's the hard truth. But
Yeah.
actually, that's not the end of it, right? We know we are all in practice. People have won and lost lots and lots of mooting competition. At least in my experience, what I actually find it useful now, there will be people coming to me when I meet them in social networking or even in matters. They will say, Lillian, you judge this, I met you in this competition and etc. So actually that is a very good conversation starter. Yeah.
Of course. No, that's great. And of course, it's very nice, isn't it? And I'm sure, and I know, Sean, you have the last word, but I'm sure as a Moot alumnus or alumna yourself, or any mooting alumnus, alumni yourself, if someone comes up and says, look, I know you participated before, would you be my practice judge? I can imagine we would try our best within sort of availability and possibilities to be able to help, because having benefited so much ourselves, I can imagine we only want to pay it forward, in whatever capacity that we can do, whether it's a coach or even as it's just one practice round. I can imagine that's something. And I'm taking that you are all nodding in agreement as I turn to Sean to give us sort of your closing remarks on oral advocacy. Thanks.
Thanks, Samuel. And I mean, if I could just riff off the same theme, I think the one thing that has really been a big takeaway for me from the competition is, just the idea of, you train for the competition and you have a lot of support from the seniors who've gone before you. You go for the competition, and then after you're done with that, you kind of give support to the juniors, and so there's this very nice continuity across batches within your university, within the broader fraternity, which I have really enjoyed. I mean, I still keep in contact with my seniors and juniors who've done the VIS on either side of me. So I think that's really something to enjoy, however you do at the competition.
Oh, that's wonderful. So I think it remains for me just to say thank you very much to Sophia, Lillian, Jean, Sean, for your invaluable insights and tips and contributions and guidance when it comes to preparing for the oral advocacy rounds. I think we've covered quite a bit in terms of strategy, in terms of what to think about when it comes to oral presentations, both to prepare bits as well as answering questions. And so again, let me just echo myself to say thank you very much for taking the time. Thank you very much for sharing with us all your insights and experience. And on that note, I will just turn the time, noting that we are on time, turn it to Hannah, please.
Thank you so much, Samuel, and thank you, Sophia, Sean, Lillian, and Jean again for the insights you shared today. Thank you.
Thank you.